Been an attorney for over 32 years, and people often ask me, what is estate planning? In this video, you will learn what are the essential documents in an estate plan. Do you already have an estate plan? Hi, I'm Mark. I'm a Texas attorney, and in today's video, we're going to learn the basics of estate planning from a legal perspective. What is an estate plan? First and foremost, an estate plan starts with a transfer method of the assets in the estate at the time of passing. Typical forms of transfer methods include a will, a trust, or some other mechanism to transfer the assets through a transfer on death deed or a beneficiary designation in a contract with any company or institution. An estate plan often also includes powers of attorney, declarations, and authorizations that may be necessary if you become incapacitated or unable to make decisions regarding your financial and medical needs. What are the transfer methods you can use as part of an estate plan? One method you can use is to execute a will, identifying your beneficiaries of both your real and personal property. Another method is to create a trust in which all of your assets are placed into a trust. A trustee is appointed, and at the time of your passing, the trustee will distribute the assets according to your wishes without the need for court intervention. You may also use a beneficiary designation in any contract that you have with any company or institution that will avoid assets going into your estate at the time of passing. Another method for transferring titles is to use a transfer on death deed for real property, including mineral interests. If you file a properly executed deed in the county records where the property is located, you can identify who will receive title to your property at the time of passing without the need for probate. The last transfer method is the laws of intestacy, in Texas referred to as descent and distribution. If you choose not to have a will, if you choose not to have a trust, if you choose not to make beneficiary designations for any of your contracts with any 401k, IRA, managed retirement accounts, life insurance, annuity contracts, if you choose not to make beneficiary designations, and all of those products are payable to the estate, and you have no will, and you have no trust set up, then Texas law will identify the distributees of your estate once they have gone through probate and proven your family and marital history, paid debts, administered the estate. A distribution to the people identified at law can occur. What types of powers of attorney are available for an estate plan? There are two main types of power of attorneys that get executed as part of an estate plan. One is referred to as a statutory durable power of attorney, often referred to as a financial power of attorney. In this document, you're able to appoint what's known as an attorney in fact. Obviously not a licensed attorney, but we do refer to them as attorney in fact because they have the authority to stand in your shoes once you execute the power of attorney and give them the rights to make certain financial transactions on your behalf. A medical power of attorney gives an individual authority to make medical decisions in the event that you become incapacitated or otherwise unavailable to make the decisions. What declarations can I make as part of an estate plan? The most common types of declarations that get executed as part of an estate plan include declarations of a guardian for yourself, both of your person and of your property. And those may be different individuals. You may have a preference that one person look after you personally while you identify another individual to look after your financial affairs. It's based on the talents of each individual that you choose. You can also execute a declaration of guardian with respect to minor children, both to take care of them personally and to take care of their financial estates. Another type of declaration that you can sign is referred to as a directive to physicians, also commonly called a living will. These are instructions to your physicians regarding life-saving measures, and you can make your wishes known directly to the physicians and not rely on someone using a medical power of attorney to apply their opinions as to what your wishes are. The last type of declaration you can make in an estate plan is referred to as an anatomical gift statement. We're all familiar with the fact that in Texas, our driver's license can identify us as organ donors, but that's limited to the organs. If you have a strong desire to donate your entire body to science, for example, execution of an anatomical gift statement will allow you to make your wishes known. Another document that's commonly executed in an estate plan is a HIPAA authorization, giving individuals immediate access to your medical records if the need should arise. As long as the document is compliant with the requirements of the HIPAA Act, you can execute this document and give the person that you trust immediate access to your medical records so that decisions can be made when you're incapacitated. What is the decision tree for an estate plan? How do you go about making choices that's right for you? The first thing you need to do is identify the assets that are part of your estate. Have you made a plan for your assets to be delivered through beneficiary designations outside of the estate? Or do you have a strong desire to have all of your assets placed in the estate, subject to debts and creditors being paid, and then have the remaining value distributed to your beneficiaries? The first thing you must decide is the transfer method. Do you wish to use a will? Do you wish to place all of your assets into a trust, therefore bypassing the probate process? Or do you wish to rely upon Texas intestacy law, known as descent and distribution, and let your heirs go to court, pursue probate, identify the creditors, the debts, the claims of the estate, the assets of the estate, administer the estate through the probate process, and then make distributions at the end? What choice do you make for the transfer method is one of the most important decisions in the decision tree for developing an estate plan. You also have to think about the individuals that you're going to choose to give authority to act, both in regards to caring for you and your person and caring for your financial health and the estate that you wish to leave to your beneficiaries. If you're considering developing an estate plan for your estate, it's important to consult with an attorney near you, speak to a professional, provide them all the relevant information that you have, and tailor an estate plan that makes sense for you. Do you already have an estate plan? Many people don't think about it because, quite honestly, contemplating our own mortality is not one of our favorite pastimes. But it is important to know that if you choose not to have a will, if you choose not to have a trust, if you choose not to identify beneficiaries through the contracts you have with life insurance companies, annuity companies, with financial institutions, if you choose to do nothing, know that the state of Texas will provide certain laws referred to as descent and distribution, commonly known as intestacy, and they will pass your assets according to law. The idea of intestacy simply means that you are not a testator, that you did not make a last will and testament, that you did not identify who you wish your beneficiaries to be through a properly executed will. Know that any choice you make is going to affect the assets that you have placed in your estate and your lifetime of effort to create wealth to pass on to the next generation. That's all the time we have. The outro music's coming. See you in the next video.